So, okay, let's just get straight into it with a bit of background about this mediation directive from the European Union. What it intended to do was basically to encourage mediation as a way of facilitating disputes in the European Union. It really wanted to avoid worry and time and the cost of court litigation that citizens face daily when they bring a case to court, and that it would enable them to get their legal rights in a more efficient way, just as Sven was explaining beforehand. In terms of application, this is applying to cross-border disputes in civil and commercial matters. So obviously it doesn't apply to things like criminal law or whatever that are not within that definition. And by cross-border, it's referring primarily to disputes within the European Union between different member states in the European Union. But obviously, where one of the parties is from Europe, they will be applying the spirit of this directive. So the main substantive rules of the directive, just very quickly, are it's designed to try and encourage mediators to be trained and make sure that the mediation that's offered in the European Union is of a high quality. As Sven said, there is some margin for judges being given the power to try mediation first, but obviously that would only be in cases where it was appropriate. And of course, enforceability of mediation agreements or settlement agreements is an important issue. And the directive talks about the possibility to get sort of approval by a court of these mediated settlement agreements, or take them to a public notary in an EU member state and get them certified by that notary. The fourth issue would be confidentiality, which the Mediation Directive really takes very seriously. And as we all know, confidentiality is absolutely key to mediation. So it's the idea is that the mediator shouldn't be obliged to give evidence in a court about anything that happened in the mediation process. And then lastly, there's the guarantee that the parties should be able to take the case to court should they not be able to reach a settlement via mediation, and that therefore any court proceedings will be suspended while the mediation is going on. The definition of the mediation under the directive, actually you saw that with Sven, so it's just that it's a structured process. The disputants to that process attempt on a voluntary basis to reach a settlement, and that they're assisted by a mediator. Now, this can be initiated by the parties or by an order of the court. That's rarer, but it can happen. And it can be foreseen as a matter of member state law. As Sven explained in the first webinar, usually mediation is not mandatory in most states in the European Union. However, there are some exceptions to that, and those would be covered by this mediation directive provision here. The mediation directive doesn't actually cover judges mediating cases in court, so-called judicial mediation. That's not covered by this directive. Anyway, basically, what happened when the EUIPO Boards of Appeal set up a mediation service right at the end of 2011 was that we sought inspiration from the EU Mediation Directive, as well as the European Code of Conduct for Mediators, which is a code of conduct drawn up by the European Commission. Now, insofar as our trademark and design regulations at the EUIPO are concerned, our legislation in the EU does actually contain a provision that EUIPO staff members may help parties in reaching a friendly settlement. So basically, we've built on this provision in the mediation, in the regulations on trademarks and designs, in order to bring in mediation. Now, on top of that, we had a decision from our executive director of the EUIPO that approved the idea of mediation within the Boards of Appeal. That was again taken in December 2011. And then we got busy drafting a mediation agreement. That's a document that actually enables or it regulates how the mediation process is going to take place at the EUIPO. So don't confuse that with the settlement agreement. That's not the same thing. It's simply telling parties how the process is going to be confidential, where it's going to take place, the parties have to fill in who will actually attend the mediation and the date of the mediation and who the mediator will be. We then got busy. Also, obviously, we had to draft rules on mediation and instructions to parties and frequently asked questions that we put on our website. In terms of training, our staff needed to get accredited. So we trained up a first batch of mediators with the Chartered Institute of Arbitrators, and then subsequent batches of mediators with the Centre for Effective Dispute Resolution. And we actually brought the number of mediators up to about 20 staff members. So everything was or is internal at the EUIPO. All the mediators are internal staff who've been trained and gone through this accreditation process. But of course, having a diploma isn't enough. We needed to prepare staff with mock mediations. In fact, we still do that as part of continuing education. We organize 2 mock mediations a year. Then in the first mediations, we used co-mediators so that 2 people would get experience. And we did shadowing. We had a system of shadowing mediators where our mediators went to other organizations and sat in on mediations, either as a co-mediator or a shadow mediator, before handling their first mediations. In terms of the quality of our system, we thought that it was important to get ISO certification. So we've actually, the whole office is ISO certified, and the mediation service that was set up is ISO certified as well. Now, let's just drill in a bit to what about this mediation? What is the mediation? What proceedings are covered by it? Well, as Sven mentioned in the first webinar, we're looking here about inter partes proceedings. So that means at EUIPO level, oppositions, cancellations based on relative grounds, and also designs. It would be invalidity of designs. Now, when's it possible? Well, It's primarily possible before the boards of appeal, again, as Sven explained. However, there are so it's enough that one of the cases involves a case that's pending before the boards of appeal to then be able to bring in any other proceedings pending elsewhere in the office. Or, as Sven explained, it could be anywhere else, either nationally within the EU or even outside of the EU. And it could also be involving other IP rights. Now, in fact, because of the current COVID-19 situation, we're actually on the verge of setting up a specific service for small and medium-sized enterprises where we would, for unrepresented parties, we would be looking to offer mediation at an earlier stage in oppositions, and we would also offer both for unrepresented and represented parties the possibility of mediation in cancellation proceedings as well. So it is a service that is expanding, and that's why we were very conscious of the question that was asked in the previous webinar about when's the right time to mediate, and obviously the answer probably is as soon as possible. But sometimes the mediation actually or the dispute needs to mature a bit, and sometimes it can be beneficial to actually try and solve it at the level of the boards of appeal, because you've already got answers to some of the legal questions, and therefore there's some more clarity on the legal issues, which then enables the parties to move on more easily to the business interests and needs. If the case is mediated before the boards of appeal, you actually need to file a notice of appeal, and you should have basically an admissible appeal in order to initiate the mediation. Why is that? Because the mediation, there's no separate fee for mediation. It's actually included in the appeal fee. The problem that we were always very conscious of is that if we're providing an internal mediation service, it's obviously possible that we're not able to solve the problem, or the parties are not able to settle their dispute in mediation, in which case, of course, the case goes back to the normal procedures in the EUIPO. And it's very important that the person that's acted as mediator doesn't have any involvement in actually deciding the case if the mediation is not settled successfully, and the case goes back to the normal procedure. So the deciding person or the decision taker in these cases will not be the person that acted as mediator. Now, the process is, as we've mentioned, voluntary and confidential. I mean, confidentiality is absolutely crucial to any mediation process for all the reasons that Sven explained in the first webinar. And we're primarily focusing on business interests and sometimes personal needs and interests, but we're trying to move parties away from purely positional bargaining, and that obviously means because we have legal representatives, i.e. the lawyers that are attending, it's quite common that we start off discussing the legal issues because the lawyers are very keen to come with what they know best, which are the legal arguments. And then we have to try and drill down into what is actually behind those legal arguments. That's to say, it wouldn't be usual that the owner of a trademark, who's the business person, is being kept awake at night by the likelihood of confusion. That's not what's keeping him or her awake at night. It's the business interests that are behind those arguments on likelihood of confusion, and why that party felt compelled to start arguing about the trademark or the design. And as Sven mentioned, it's possible to include parallel disputes between the same parties, either anywhere within the EUIPO or anywhere else in the world. How would the mediation actually be initiated? Well, basically, there are two ways. The first would be a joint request for mediation from the parties, from both parties. And here you see the form that would be used. And the other way would be that the reporting judge at the boards of appeal looks through the case and sees that it's a case that he or she thinks is appropriate for mediation, and then suggests to the parties a mediation. And if both of them agree, then the case will be mediated. We'll be looking at this in this process tomorrow in a bit more detail. Again, the steps of the mediation, we're going to look at this tomorrow, but for those of you that are mediators, essentially, you know already these steps, and essentially the style of mediation that we most often use at the EUIPO is the facilitative style, although there may be times when it's appropriate to have some more evaluative style, or even transformative if there's a strong personal relationship element there. Now, I haven't got time to go into all the differences between those styles, and probably it doesn't matter for the purposes of just explaining the steps of the mediation here, but I'm happy to do so at a later stage in questions or whatever. But we look at we obviously have a strong preparation before we ever get to the actual mediation day. That's contacting the parties. Then we have an opening phase in the actual mediation where both parties, it's a joint meeting, and the issues that need to be discussed are an agenda's made basically of those issues at that opening meeting, and then we go into the exploratory stage, which is individual meetings with each of the parties, trying to find out, going behind the positions and into the needs and interests of the parties, and the business needs and interests more specifically. Then we go to the bargaining phase, normally where the parties they look for solutions, they suggest solutions. These are there's an exchange of possible solutions. Bargaining usually is the result of that, and then hopefully there's a conclusion where an agreement is tentatively reached, and we would aim to do heads of agreement within the same day of the mediation. Again, I'll go into all of this in more detail tomorrow, but that's basically the bare bones of it. What are the sorts of cases that we've had? Well, there was the one where we had a multinational in the energy sector, and it was very unhappy about a trademark that had been filed by a small company, because the small company did energy audits, and the multinational felt that the energy audit, the environmental audits, but specifically, those environmental audits would clash with the energy sector, because there's obviously environmental impact assessments which are done for companies involved in the energy sector, and therefore there was a potential conflict between the areas of activity conducted by both companies. And unfortunately, this had got very personal because the small company, the owner of that company, felt that he was being persecuted by the multinational, and he sort of had gone into, if I could put it this way, kamikaze mode, thinking that he preferred to lead himself to bankruptcy and fight everywhere he could with this company rather than give up and try and find a compromise. Fortunately, we were able to make him see that perhaps this was not the best way forward, and that there were a lot of conflicts all over Europe and even in the USA, and this was costing an awful lot of money, and he wouldn't really benefit by trying to commit financial suicide in this way. So the parties actually managed to settle by the multinational agreeing to buy the small company's trademark. And another case which was somewhat similar, but this was in a totally different sector, in the alcoholic beverages sector. The problem was that an individual had set up a bar, basically, while it was a very, very nice wine bar, but which used partly or made an allusion to the name of the Drinks Association's trademark. And they were very unhappy about this, and they had a policy of a zero tolerance policy towards infringement. And they obviously started proceedings both at the EUIPO and nationally in infringement proceedings. And again, we were able to ensure that there was an agreement between the party whereby the individual would stop using the mark, and that would be actually the use of the mark would be phased out over a period of time. And he basically got some compensation from the Drinks Association to rebrand, and for the costs of doing that. Now, why did the Drinks Association agree to that? Well, they were obviously a lot more powerful than him, but they realized that actually pursuing people in court and before IP offices is time-consuming and not a good use of company resources. So they preferred to settle and just do it all discreetly, and the confidentiality aspect was important to them. Okay, moving on. Well, we realized that in fact mediation's a great tool, but sometimes you need to offer other things as well, because unfortunately some people are hostile to the word mediation. So when they hear mediation, they think that, that's all a load of nonsense, or we don't like that. No, we never do that. So sometimes you have to use other terminology or offer other tools to try and get to some dispute resolution that doesn't follow the mainstream and is beneficial for everybody. So what we've developed at the EUIPO Boards of Appeal is we've actually now evolved into an ADR, an alternative dispute resolution service. And we offer also conciliation. And that this just basically means we propose a solution to the parties, because in the mediation, it's the parties that come up with their own solution. The mediator tries to get them to be creative and try and think outside of the box. But in conciliation, we actually will suggest solutions. For example, we may suggest a territorial delimitation, that the one company operates in a certain number of territories within the European Union, and the other company operates in other territories. Or we may even foresee a limitation of the goods and services to try and make sure that each party stays off the core areas of activity of the other. This actually proved to be quite popular. Now, I know you asked for some statistics, so I would just say here that actually last year we had 85 mediation and conciliation cases submitted to mediation and conciliation, and of that 85, only 10 involved mediation. So you can see that conciliation has really proved to be very popular. But thereafter, it really follows quite a similar process to what's described in mediation, except that we're actually coming forward with potential solutions. And this year so far, we've got 33 cases submitted to conciliation and mediation. But of that figure of 33, only 3 so far are pure mediations. Now, we think that the parties need flexibility in the ADR processes, and I'm going to come on shortly to the other areas that we're, or the other tools that we're proposing in ADR. Now, we also created a stakeholders advisory board at the end of 2018, and they have already. We came up with the idea because of that of expert determination, offering that as another tool, and sometimes that can be used with mediation. So, for example, if a party is adamant, is insistent that it has a very strong legal case on a particular issue, but maybe as mediator, we know that this is perhaps not really quite the reality of the situation, but we may suggest that the party seeks an expert determination, and that issue would then quickly be referred to to experts, the expert would give an opinion on the legal issue, and then we can continue on with the mediation on the basis of that opinion. Now, obviously, the opinion is not it's not anything that's binding on the parties, but it gives them a clear, objective, independent opinion on the legal merits of a particular issue of their case. Going back to just to give you an idea of the structure of our ADR service, and I would just like to go in a bit more detail into this stakeholders advisory board, because I think it was quite crucial to the way we set up things. So we actually have a four-pronged approach to the advisory board. So the people we invite are EU institutions and national IP offices. And then we have business associations from a broad range of business interests within the EU. So we have like the digital, small and medium-sized enterprise digital sector in Europe. We have fashion sector. We have the car industry, automobile industry, and so forth. And we have other ADR institutions like the WIPO and the International Chamber of Commerce, and IP professional associations, both of so-called users, so the people that are using our system, which are either trademark attorneys or lawyers from associations of lawyers at European level. And all these interests feed into this stakeholders advisory board, giving us opinions on what the people on the ground actually want out of alternative dispute resolution, what's important to them. As I've said here, I don't think we need to go through all this, but it's just basically the idea is to get some sort of a steer, if I can put it that way, from this advisory board about whether we're on the right lines with the initiatives that we're taking. Based on the input we've got so far, what we're working on now is online dispute resolution. Obviously, now everything's switched to an online environment, and all our mediations and conciliations are being done online. Early neutral evaluation is something we're working on right now about, as Sven was saying, getting as early as possible into the life of a dispute, even just as it's starting, but before it's matured, so that we really try and give assistance at the earliest possible stage. We're looking at assisted negotiation of parties. So, when they first have a problem, when they're trying to solve it, we can step in and try and help them. And non-binding adjudication. This is a bit like the expert determination that I mentioned, but you could have a situation where the matter was an adjudication was made on the case, and then because it's non-binding, you've then got some clarity on the legal issues, and then you move forward on concentrating on business interests, and hopefully there's not so much argument about the legal interests, first of all. And then pledges. This is an idea that the companies will undertake to use. So the key users of our system, or anybody using, any company that uses the European trademark or community design system, can sign a pledge saying that if they have a dispute with anybody else that's also signed the pledge, they undertake to use the EUIPO Boards of Appeal ADR service. And as Sven mentioned earlier, we're working on contractual clauses to put in, so that companies can put these into their contracts, so that if they have disputes on transfer agreements or licensing or whatever, that they can also submit those to the EUIPO Boards of Appeal Alternative Dispute Resolution Service. And then finally, that we could have hybrids of any of these. So something like MedArb that you may have talked about. That was really what I was getting at with the adjudication, the non-binding adjudication, that you can combine it. You can start off with that and then move into a mediation to try and reach a settlement. So we're doing quite a lot of things. Again, we're looking really at how we can support small and medium-sized enterprises. This is especially important with the coronavirus and all the economic, I would say, chaos that this is causing and will continue to cause for quite some time to come. Business outreach, obviously, use of artificial intelligence. We're looking at whether we could have programs for predicting the outcome of litigation, either at the EUIPO or elsewhere, that would then be used as a sort of reality test for in the negotiation phases, and would help bring companies to making, in the context of the mediation, try and bring the companies to make proposals, but making them in a very informed way, knowing what the likely outcome is if they don't negotiate, and if they go to court or continue at the EUIPO, and done in a very neutral way, so that we don't jeopardize in any way our neutrality as mediators. And again, looking at tailor-made dispute resolution systems, and generally conducting training and awareness raising amongst users in the IP community on ADR tools. Okay, well, that's all from me. I'm happy now to take any questions that anybody has. Thank you.
Thank you, Gordon. We have quite a few questions, actually. The first one is on what are the qualifications of the mediators for EUIPO, and whether these mediators are examiners handling the appeals, or are they independent of the EUIPO?
Okay, so if I've understood correctly, the first part of that question is, where do the qualifications come from? Well, they're the Chartered Institute of Arbitrators, which is it's of Arbitrators and Mediators, which is an international organization based in London and with branches all over the world. We all did. A number of us did courses with them. It was a 1-week course, and then followed by 2 days of examination. We also have the Centre for Effective Dispute Resolution, which is again an international organisation. We're dealing with the Irish chapter of that, and this organisation did a very similar job to the Chartered Institute of Arbitrators, the same format. In terms of who are our mediators, as I explained, it's all internal people at the moment. That's because we're offering this service essentially for free, and there are not many ADR organizations that want to do everything for free. So in order to do that, we use internal people. So we have the members of the boards of appeal and some other staff in the office that are involved as mediators. But as I explained, if those people are involved as mediators, they will not be involved as decision takers in the cases involving those same parties, and that particular dispute. Okay, I hope that's clear.
Yes, for me, that's clear. I guess this is also related to the connection between EUIPO staff handling the IP applications and the functions, the mandate of the boards of appeal. The question is, how independent is the mediation process from the trial board or the adjudication process relating to the IP application or IP grant? Is the information disclosed during mediation proceedings kept totally confidential from the adjudication board or body handling the case, the appeal?
Absolutely. So we're very strict. Tomorrow I'll get a chance to go into this in a little more detail, but essentially when the mediation ends, the mediator destroys all notes and papers. And we do not discuss with colleagues elsewhere in the office about the mediation. I mean, we just don't do it. It wouldn't work otherwise. So we have to be we take confidentiality very seriously, and we take independence and neutrality very seriously. And as part of that, we make sure we don't participate in the decisions once they've been, if ever the mediation isn't successful in reaching a settlement. We're very strict about that. I should also say that actually in about over 70% of cases we do manage to reach a settlement. So the settlement rate is quite high.
Unlike arbitration, is there a potential problem regarding cross-border enforceability of agreements arising from mediation? And what is the role or relationship of the Singapore Mediation Convention for instances where you want cross-border enforcement?
Well, on a very quick word about the Singapore Mediation Convention, which incidentally Sven and I were lucky enough to actually witness the signing of that convention. It is a very good convention. Unfortunately, so far the European Union has not signed that convention. However, it should be stressed that the biggest users of the EU trademark or trademark system in particular are actually not Europeans. They're the US and China. So the US and China are members of the Singapore Convention. And so any party that wanted to make the settlement agreement, if it was a dispute, say, between an American company and a Chinese company about European Union trademark or other rights, or rights that involved, in any case, at least one European Union trademark or design, then it would be possible for them to make the settlement agreement subject to the Singapore Convention when that's finally in force. In normal circumstances, if only one of the parties, or say one of the parties is European and the other party is from somewhere else, it's still possible, as I mentioned before, you can take the agreement, the settlement agreement, to a public notary, for example, in Spain. I mean, unfortunately, the rules do vary from country to country, but certainly in many countries, you can take the settlement agreement to a public notary, and then it becomes an enforceable document by any court. And also, it's possible to go to the court, a national court, and get them to endorse the settlement agreement. The only downside of doing that is, by doing so, it becomes a public document, which maybe some people don't want. So perhaps the best way is the notary in Europe. But we haven't actually had feedback of problems about enforcement. Generally speaking, when parties have made the effort to actually go through a mediation process and agree on a settlement, they usually stick to that settlement. We have not yet had feedback about problems on that, and I hope we don't. I mean, there are, of course, things that can be done. You can have clauses in the settlement agreement that even foresee an arbitration, for example, and then it becomes enforceable under the New York Convention. That's another possibility. I mean, but the EUIPO Boards of Appeal mediator doesn't actually get involved in the legalities of enforcement. That's why the parties, more often than not, are legally represented. And that's what their lawyers are supposed to be looking at and making sure that it's covered.
Okay, for the next question, it's more about the concept of conciliation versus mediation. Mm-hmm. So a couple of questions on that. First, what are the usual reasons parties choose the process of conciliation over pure mediation? So I guess we answer that first before you proceed to the next question.
All right. Okay. Well, so basically, if we saw, let's go back one step to what just a very quick word on the European Union trademark system. In our system, you don't have to show use of the trademark or even initially an intention to use in order to register the trademark. You only have to show it 5 years after registration, and then only if you're challenged by another party that you haven't used the trademark. So what that means is there are quite a lot of trademarks on the register where there a very wide range of goods and services are applied for, but in fact, the companies or the owners are not using the trademark for all those goods and services. So when we get conflicts between these trademarks, obviously we can sometimes see that in fact the core business of these companies is a bit different. I mean, to give you an example, I once had a case where one party was using software for nanotechnology, and the other party was using it for the visually impaired. Okay, they both had software, and therefore, on paper, there was a conflict. But in reality, they were using it for different things. So when you become alive to these differences in actual use, then that would be a very good reason for proposing a conciliation whereby you said, okay, let's actually put in the list of in the specification what you actually use this this trademark for. Again, another example would be geographical limitations. So, for example, there was another case where there was use, I think it was for financial services, and one party was actually really targeting the Nordic countries, so Sweden, Denmark, and Finland, whereas the other party was interested in other regions of the EU. So there we saw that, and we proposed, okay, why don't you just say, you put in a territorial delimitation into a coexistence agreement, and that's what they did, and they found a solution like that. So these would be more conciliation cases. Of course, you could do that by mediation as well, but there where you see that there's a solution that you think would be practicable and workable, you suggest it to the parties. They're free to say, no, we don't agree, or yes, we do. And you try and work out with them a compromise, basically. Okay, whereas in mediation, the parties, we create the situation where they come up with their own solutions. We don't impose the solutions. We don't impose the solutions in any case, but we don't even often suggest solutions in mediation unless we really see that the parties are absolutely struggling to be creative and they're just not able to come up with some ideas. But even then, the idea of mediation is that the parties should come up with their own ideas because they're likely to be the most durable and sustainable, rather than ones that come from a third person. But in conciliation, the concept is quite different, that actually we can see that there's potentially quite a relatively easy solution, an easy fix, if I can put it that way, to the problem. Okay.
Okay, and in that case, would the proceedings or procedures for conciliation follow the same step-by-step process as mediation, or are there any differences?
There are usually differences because we don't meet in person. I mean, obviously, at the moment, none of us are meeting in person. But in the pre-COVID-19 days, we would typically handle a conciliation by making phone calls and following up with emails and just trying to solve it through an exchange of, an initial telephone conversation and then exchange of emails and maybe a follow-up telephone conversation to try and solve the issue. Whereas mediation, we would need a full day actually meeting with the parties, sitting around a table and trying to work out a solution. So the process is a bit different, but of course, if you see that a party is having hesitations about whether to accept a conciliated suggestion or not, you might use the reality testing techniques, which I'll go into a bit tomorrow, which are like the worst alternative to a negotiated agreement or the best alternative to the negotiated agreement, and see whether in fact this suggestion is in the zone of possible agreement and therefore is actually an attractive option.
Yeah, so further elaborating on conciliation and mediation, how about the outcomes of the two proceedings in terms of enforcement? How is it different having an agreement under conciliation versus a contractual or settlement agreement via mediation?
Okay, so in terms of enforcement, I think that for conciliation, this is not really an issue because what would happen would be the parties would, if we, for example, suggested a limitation to the list of goods and services, they would incorporate that limitation into their list of goods and services. And then they would both send us a request saying withdrawing the appeal proceedings before the boards of appeal. So that would actually end the appeal before the boards of appeal. I mean, if they then had, if then one of the parties didn't respect the terms of its even if it didn't respect the terms of its goods and services, it actually wouldn't have protection for its trademark beyond what the limitation said. So it would, I think it would be quite difficult to envisage enforcement issues for conciliation. And for mediation, well, I explained, that was the first question. I already explained at some length what would happen there. But I would repeat that we've never had so far issues about parties coming to us and complaining about enforcement issues. I think the idea is, and it's something that Sven said, it's a voluntary process. So you actually have, it's assumed that the parties are acting in good faith and that they're willing to give and take. So once they've shown that willingness, it would be quite unusual that they then did a 360-degree turn and started, started to go back to an aggressive or a behaviour that was in violation of what had been agreed. But of course, it could theoretically happen, and as I say, there are mechanisms for that. But conciliation, that's not really an issue.
So now we go to arbitration. In terms of the cases handled by the boards of appeals, how much are mediation cases and how much are subject to arbitration?
Okay, I mean, we don't do arbitration as such. We're looking at this non-binding adjudication. We haven't yet done that. So that's a future project that we're working on. And the idea would be that it was combined with mediation. So you would do the non-binding adjudication. Of course, if the parties were perfectly satisfied with the adjudication, then they wouldn't progress to mediation. But if they weren't, then you could progress to the mediation. What we have at in the boards of appeal are decisions that we take, which is our day job, if you like, which are taken as a panel of three, and obviously have quite a lot of similarity to an arbitration. But the big dissimilarity is that our decisions can be appealed to the EU courts, that Sven, the Court of Justice, as Sven was explaining this morning, and the process can take years sometimes. I mean, Sven gave some examples of 23 years, and by the way, that case of 23 years is still ongoing. So, in terms of what's the percentage? Well, the vast majority of cases we're deciding by. I mean, Sven said we have nearly 3,000 cases that we decide by a decision, and we have 85 cases that go this alternative route. Now, okay, it doesn't sound a lot, but actually the thing about the alternative route is when you do manage to settle these cases, it's extremely satisfying because you really feel that you are helping both parties. You're not just saying, okay, one of you's a loser and one of you's a winner, now go. You're actually trying to help the parties, sometimes mend relationships and go on with their business and hopefully, get back to doing business, not spending 23 years with courts and lawyers.
Thanks, Gordon. For now, we have only time for one last question, and it's about the concept of IP rights being jurisdictional or territorial. How do you deal with the choice of law question in mediation settlement agreements? Is this a primary consideration, especially for the boards of appeal?
The short answer to that is that we don't deal with the settlement agreement. That's the lawyer's job. And obviously that is a negotiated issue because normally each party wants its home jurisdiction and home law. But again, parties find a solution. I mean, one solution that is possible is that because everything's happened in Alicante, they take Spanish law and Spanish courts as a fallback position, which actually, by the way, is envisaged in the European Union trademark regulation, that it's always possible to, if none of them have any presence in the EU, for instance, then they can fall back on Spanish law and Spanish jurisdiction. But I mean, it's obviously going to make sense to have a jurisdiction where they've got assets, because if you need to enforce, you need assets somewhere. And if you have everything regulated in Spain and nobody's in Spain, then that doesn't make much sense, because then you've got to enforce a Spanish judgment elsewhere, which might be very complicated. But again, we don't get involved in that. And I've never heard anything I've never personally come across a problem with this. And to my knowledge, nor of any of my colleagues.
We end our meeting. Thank you very much to all the participants.